Right. Welcome, everyone, for joining us this evening. We apologize for the last minute room change. We have a building issue, but we're glad everyone found it and made it. And thank you for making time. For those of you joining us online, we will go ahead and kick off with attendance. Commissioner Anika? Yes. Commissioner Charles?
Present.
Commissioner Selena? Commissioner David?
I'm here.
Commissioner Jim is not with us tonight. Commissioner Dansby?
Present.
Sorry, Commissioner Joshua, Commissioner Julie here, Commissioner Lisa. Here. Wonderful. Well, a very big welcome to Joshua Dansby, who is our newest COB member. He will be kind of completing the training program, but we encourage him to participate in the discussion this evening. And thanks for making the time to kind of get up to speed on short notice. Do you want to say a few remarks about joining the COB?
Just grateful to be here. I'm happy to work with everybody, and I hope, of course, we can really press and make, just in that progress to work together to, of course, achieve and address what I'm sure are valid points from everybody's perspective. But thank you. Look forward to working with all of you. Thank you.
Okay. We have one correction on the February meeting minutes, just on attendance, that Anika was with us in person. But other than that, I didn't see any issue with January. Charles, do you have a copy?
Sweet.
Does anyone else notice anything we need to add or amend? Otherwise, your motion to approve the January meeting minutes?
I'll move to, so was January the one where the
February is the error.
Okay, so
we'll wait
to approve the January COB minutes.
Okay, do I hear a second?
Second.
All in favor, aye.
Aye.
Aye. Opposed, nay. The abstentions, great. Okay, we will go ahead and jump right into the case review tonight. We're going to use a slide deck format to kind of guide our discussion. So Dave, I'll kind of open this up and then we'll stop at each slide if you want to. Okay. Okay. So we will just do a quick discussion preview. Go upside down. So the review, the goal of these case reviews, which just to remind folks who are joining us online, I do see we've got some new people. When we review these cases, our purview is to look at what's already happened, but the real goal is to identify what would improve public trust in the future. So in the first part of this, we're going to go through the case review and look at the situation, what was the events leading to the complaint, look at relevant policies, look at the individual officer actions, review both the ACPD's Office of Professional Responsibility investigation outcome, as well as the independent policing auditor's outcome, their determinations of whether policies were violated, and then we'll discuss and vote on our findings. The purpose there to provide transparency and accountability, but really to fuel an understanding of where we are with current policies and procedures, so that we can look at what are the consequences for public trust and make recommendations to improve accountability and trust in the future. So what we're hoping to achieve tonight is to be able to go through this in a little bit more kind of sequential manner, so that we can be thorough in our conversation, but also advance towards our ultimate goal, which is to, be able to make recommendations or look into additional information so that we can improve situations in the future. Any questions? So Dave and I will go over the complaint, and then we'll have another section where we can do kind of additional context from the IPA and the ACPD. This was from a case that originated in October 2023. It took place at the county office buildings, and unusual to our normal cases, we typically, are in need of protecting the anonymity of the complainant. But in this case, because the Commonwealth Attorney was the complainant, we will review this. There were several members of that staff that were involved as witnesses, and then 3 officers. Officer 1, a senior officer who was ranking of the 3, male, Officer 2, who was also a senior or supervisory officer, and Officer 3, who was an earlier career officer, female. And the complaint was that the independence of the Commonwealth Attorney's Office was violated, that ACPD officers interfered with the grand jury testifying without being noticed to appear, and specifically about Officer 1, that they repeatedly engaged with staff from the Commonwealth Attorney's Office in an inappropriate and unprofessional manner. So to get this conversation started, there were 2 kind of relevant backstory cases that fueled into the interaction between the Commonwealth Attorney's Office and the officers involved. We're going to go over these at a high level just so that there is enough context to talk about, what's necessary for the case. But in general, a year prior, there was a driver, person X, who was driving erratically and brandishing a firearm, fled from officers by car. That led to a pursuit that started in Arlington County, ended in Fairfax County, and the person was firing their weapon out of the window before crashing the vehicle and was apprehended by Fairfax County Police. No officers were injured. Person X was charged with several offenses, including attempted malicious wounding of a law enforcement officer for the firing of the weapon. And from this case, Officer 1 had strong feelings about the case outcome, and that kind of tension is what led to a disagreement with witness 1. Case Y, which was the case being heard by the grand jury in this case, was a person who had been attempting to flee ACPD in a stolen vehicle. Because of their kind of maneuvering of the vehicle, ACPD had to pin them between 2 vehicles to kind of keep them from being able to flee. And Officer 2 was involved in this case and sustained an injury from broken glass when they were apprehending person Y, who, once the vehicle was pinned, was not responding to command. So Officer 2 had to break the window and pull the person out through the broken glass. Because of that, Officer 2 needed medical attention and was taken to the hospital at the end after person Y had been apprehended. And Officer 3, who was not on scene and had not been involved with the kind of front end of this incident, completed the arrest and was listed on the report, although she was not as involved in the pursuit and apprehension. Does anyone on the COB have questions kind of about that leading into the next section? Okay. So the grand jury, the subject grand jury in this case was scheduled to hear case Y, where Officer 3 was the officer of record, but Officer 2 had actually been the person involved. So the Commonwealth Attorney's Office had noticed Officer 3 to testify because her name was listed on the report, which is typical. Officer 2 had reached out to the Commonwealth Attorney's Office by email and text and had not gotten a response. So Officer 2 is kind of frustrated and trying to make sure that there is an opportunity to testify in this case where he was injured, and brought the matter to the attention of Officer 1, who is the ranking supervisory officer. And Officer 1 called a meeting with Officers 2 and 3 to kind of figure out how to handle the situation. So Officers 1, 2, and 3 meet and seek out witness 1, a member of the Commonwealth Attorney's staff, to express frustration about both of these cases. During this meeting, the conversation between Officer 1 and witness 1 escalated into a heated argument. There were profanities exchanged, initiated by the witness. They were kind of ultimately able to have this conversation, but Officer 1 ended the conversation telling witness 1 that they were going to go up and testify before the grand jury. During the interview of Officer 1, he recalled that witness 1 replied to that intention saying something like "good luck" or "that's not how that works." So all 3 officers proceeded to enter the grand jury room at the same time. All 3 officers were sworn in, but that's not a sequential process where being sworn in admits you into the grand jury room, and is different from being noticed to testify in the case. So they would not necessarily in that process have been physically prevented from doing so. Witness 2 from the Commonwealth Attorney's Office was sitting outside the grand jury room and reported that officers demanded to see the case file, stated they were going to testify, and recalled feeling bullied and intimidated and did not feel capable of preventing them from going into the grand jury room. So then once the three officers together are in the grand jury room, officer testimony later was determined to have tainted the grand jury. So the Commonwealth, because of what was said in the grand jury room by these three officers, the Commonwealth Attorney's Office had to issue a notice to, I have it as 17 here and 16 in another place, I apologize, but 17 other cases that were not relevant to the testimony they were trying to provide, disclosing the incident to the defense attorneys, which could have kind of disrupted the, process of criminal justice in those cases. And the Commonwealth Attorney's Office had to reconvene a new grand jury for case Y, which was, kind of excessive time and resources to fulfill the course of their duties and responsibilities. Dave, sorry, I'm kind of blowing through this.
No. So far, so good.
Okay. So that was the context for the interaction with the grand jury. There was a separate incident in the same month where Officer 1 went to the Commonwealth Attorney's Office to speak with a third witness on a separate occasion. And Officer 1 arrived unannounced, proceeded directly past the front desk, didn't check in, kind of blew past the person who was sitting there, and then criticized that person's performance. And Dave?
Yeah. Let me just, so I can add something just on the point about determined to have tainted the grand jury, which was not, so no one on the COB literally knows what was said in the grand jury. Obviously, there's grand jury secrecy. ACPD was very circumspect, didn't ask the officers what they said, was very careful. But I think it's fair to say that the Officer 1, as part of the interview, told ACPD what he intended to say before he went in. And so that's a pretty good basis for understanding what had happened. So I just want to be clear that everyone was cautious about the grand jury secrecy rules. And in addition, there was a comment made afterwards outside the grand jury that was overheard. But it's on the basis of those two things, primarily what Officer 1 said he intended to say before he went in, which gave us the and ACPD cause to believe that it was improper.
Yeah, thank you. Okay, so we can come back to those as needed, but recognizing that's kind of a lot of information, the relevant grand jury rules, we'll just kind of put forward a couple of things here for kind of context for the folks listening in. So within the Code of Virginia, the purpose or the functions of a grand jury is to consider bills of indictment. So the Commonwealth Attorney's Office prepares these bills of indictment, and then it is the grand jury's function to determine whether or not that is a, quote, true bill based on sufficient probable cause. And officers typically testify to the facts of the case in the course of that in order to help the grand jury understand whether or not there is sufficient probable cause. So then, in the Supreme Court practice, there is a requirement for subpoena for the attendance of a witness to testify before a circuit court or a grand jury that can be issued by a clerk or attorney for the Commonwealth. So, and we'll cover this again later, the normative policy between the Commonwealth Attorney's Office and ACPD did allow for kind of hot swapping or switching, where an officer, if they've got an absence or they have to be in court or for some other reason can't provide the testimony. And essentially what the officers do is read the other officer's report to provide that testimony, since they can't answer questions otherwise. So there is a normative practice of that kind of switching, but typically with notice to the Commonwealth Attorney's Office. But there is kind of an underlying written rule about being subpoenaed to the Supreme Court. In these instances, the Commonwealth Attorney's Office does not officially subpoena officers, they notice them to appear. And so you'll see that kind of distinction throughout here. But
and in that hot swapping, it's my understanding that it only occurs if that other officer who is noticed is not present, correct?
yeah, and presumably in this case where Officer 2 would have had more facts to represent it from the report, because that was their kind of involvement, that probably would have been consistent with the normative kind of protocol.
Okay.
So then also in the rules of the Supreme Court of Virginia, specifying who may be present in the grand jury. This kind of speaks to the fact that there's no one else in the room. The Commonwealth Attorney isn't there. There's no judge there. It's just members of the grand jury and one witness kind of testifying to a specific facts. And the conversations held in there are secret. The Commonwealth Attorney's Office doesn't get a transcript of the testimony. We covered this a little bit last kind of week in our preparation for this, but just to kind of brush up. So the last element here is the handbook for Virginia grand jurors, speaking to what the grand jurors kind of expect in the course of these, that they, are given a list of available witnesses who will appear in front of them. And that if any person who's not listed on that bill wants to testify, they must obtain permission from a judge, and that witnesses should be examined one at a time. So that's the handbook given to the jurors, not, necessarily something that's referenced by ACPD, but this is kind of a cross section of what the written policies are related to grand juries and our discussion. And then, yeah, as we said, kind of the normative informal policy allows for switching. So before we kind of go into this, we did want to commend ACPD for being steadfast in pursuing the sustained violation of conduct unbecoming. Getting through the grievance period requires resolve and resources, and it is a very kind of serious violation. And so we want to acknowledge that getting through that process took a backbone. This is a summary of the alleged policy violations by officer. Several of these were withdrawn. And so we have 3 policies under review: conduct unbecoming, duty, responsibilities, and efficiency, subcategory efficiency and cooperation and personal contacts. You can see the Office of Professional Responsibility findings on the left, sustaining the conduct unbecoming against Officer 1, not sustaining duty responsibilities against Officer 2 or personal contacts against Officer 1. The IPA findings sustaining 3 allegations against 2 against Officer 1, conduct unbecoming, and duty responsibilities, and also duty responsibilities for Officer 2. We'll get to our recommendations kind of as we go through. We try not to put those in writing before the COB votes, just to avoid confusion about what we found versus what was recommended, but also just a quick key reminder about sustained, not sustained, exonerated, or unfounded. Okay, so we'll go through, and the next slides have kind of the specific policy violation and the specific officer. So I've got the relevant policy language, OPR, and the IPA's findings. So I'll read this off, and then I'll give Mummy and Albert an opportunity to kind of provide additional context around Officer 1 for conduct unbecoming. The relevant policy language: conduct unbecoming by a police employee is any conduct that adversely affects the operations, morale, or efficiency of the department, or any conduct which has a tendency to adversely affect, lower, or destroy public respect and confidence in the department or any employee. Conduct unbecoming also includes any conduct that brings the department or any employee into disrepute or brings discredit upon the department or any employee.
Sure. So we're going to go allegation by allegation. Okay, perfect. So before I go into talking about this allegation, though, I do want to just provide a couple points of some additional context as it pertains to the fact that I think sometimes it's helpful to distill it, particularly for people who are listening from the public, and to understand kind of what was going on here. So we talk about case 1, or I think you referred to as case X. That's the case that involved the grand jury testimony. So you had Officer 2, who was involved in apprehending the suspect in that case. The officer had to put his hand through a window in order to get that person out of the car. It was broken with a tool, and then he had to put his hand through the window. And in the course of that, his hand was injured pretty significantly. But for the fact that he was injured and had to go to the hospital, he would have been the arresting officer and would have, based on just practice, that's usually the arresting officers who is called to subpoena before the grand jury. In this case, Officer 3, the third officer involved in this investigation, was the one that was called to actually testify before the grand jury, because that officer was the one who ended up being the arresting officer because of Officer 2's injury. And I think it's important to mention Officer 3 as a part of this, but also just kind of how Officer 3 role in the investigation kind of changed a little bit. So at the onset, we started out by investigating all 3 officers that went into the grand jury room. Throughout the course of the investigation, we learned that Officer 1, who is the more senior supervising officer, and Officer 2 were the ones that actually were not subpoenaed to testify and were the ones that gave the testimony that was deemed to be improper and had tainted the grand jury. Officer 3 was the one that was subpoenaed. That was the officer who was supposed to be in there and went in there, and as far as we know, did what they were supposed to do. It was also Officer 3's first time doing this grand jury process. And so basically, in short, the investigation showed that, and I agreed, that officer didn't really have any culpability in the matter. And so that officer became a witness versus a subject officer in the investigation. So we focused just in on Officer 1 and Officer 2. And then as it pertains to Officer 1, as I mentioned, was a supervising officer and did not have any involvement in the underlying investigation, but the investigation showed, the underlying criminal case. But the administrative investigation showed that Officer 2 went to Officer 1 expressing frustration about not getting communication from the Commonwealth Attorney's Office about what was going on with the case, and that Officer 1 also had some underlying frustrations about how some of the cases were being handled. So this, was a result of kind of a couple of precipitous events, not just something that happened out of the blue, in fairness. And that was kind of what motivated, based on what we gleaned from the investigation, their decision to take action to go into the grand jury. So now, as it pertains to Officer 1, for me, I kind of sliced up the allegations slightly differently than OPR. So for the conduct unbecoming, for me, I focused on the personal kind of one-on-one interaction. So Officer 1, just to recap, was not just involved in going into the grand jury room, but in the other case, there were some kind of unprofessional exchanges that happened over the series of both cases as it pertains to Officer 1. And so I looped all of those kind of exchanges, those verbal exchanges with the Commonwealth Attorney's staff in both cases under conduct unbecoming. I personally think that personal contacts doesn't necessarily fully cover it, especially because he's a supervising officer. And it just went beyond the scope of just one particular word that was said or one particular interaction, but was more so kind of a series of unprofessional, intimidating, condescending behavior that it was exhibited towards the Commonwealth Attorney's Office staff. So I put that under that umbrella, and then separately, the efficiency and cooperation is where I dealt with the grand jury issue. So I just wanted to make sure that that was clear in terms of how I separated the findings. I did agree with OPR's findings to sustain the allegation, but the kind of analysis for me under the conduct unbecoming was more so based on the actual verbal interactions with the staff. And that's why I then also withdrew the personal context. I felt like those kind of overlap. So that's how I distinguish the conduct. Is that clear?
Yeah.
Okay.
To clarify, Rich, on that, realizing that that's what you decided to do, can't the same facts sustain multiple?
They can, but it doesn't necessarily, I think, make sense to stack the allegations, and then they also have to still go through a process of like a grievance process, going through civil service and that sort of thing. So if there was like the same set of facts but multiple things that happened, I don't have a problem with having multiple allegations for different things that happen in the same set of facts. But if it's the same conduct, I think I go with the policy allegation that is most all-encompassing or most fitting of those particular acts.
That's mainly an administrative decision, sounds like, just for the purpose of the process.
And I want OPR to weigh in as well, but I think the way that we looked at the policy alignment with things is also just like a little bit different. So we'll cover that in a second. But Albert?
Sure. So I want to start off by saying, OPR's finding in this case for all was that it was a sustained violation of conduct unbecoming. Conduct unbecoming, I would consider to be, we were going to tier policies, would be a tier 1 policy, right? So it's considered a major policy, right? So tier one, and I thought through this to try to give better explanation and clarity on this. A tier one policy would be like conduct unbecoming, integrity, excessive use of force. Those would be considered tier one policies. Tier two, something maybe like a police vehicles violation. Tier three, like maybe wearing the wrong uniform or not shaving or something like that. So when we have a major and serious violation like this, you can see by the language of this policy, there is a lot of overlap, right? Not talking professionally with someone, not doing your best to create an efficient system. It all overlaps. So I think kind of what Joshua, right? You don't like Josh or anything. So,
Joshua's fine.
okay, Joshua was alluding to was, that when we have something like this that overlaps, what we sort of administratively do is we'll take the highest tier one policy. And then if the conduct is sustained in that case, all the other ones will be sort of, we don't like to administratively stack things against someone if there's an overlap, right? And the best example I can give is like if you crash a car and then do something, egregious against a citizen, those two things are completely wildly different than one another, right? Driving a vehicle and then the way that you interact with a citizen are two completely types of things. In this case, as we kind of learned the facts, this is about an interaction with the Commonwealth Attorney's Office and then an act that occurred, which is kind of almost similar, like your conduct during that course of this entire incident. So that's how we looked at it. And I just want to provide that perspective because I assume that we're going to be going through all these policies. And so I want to throw that out in the beginning to say, okay, this is how we looked at this. Again, this is a tier one policy, a major policy.
They're all three of these to be tier one.
No, they are not. They are definitely not. CUBE is a tier one policy. The other ones are not. I would not consider those tier one policies. So,
CUBE is conduct unbecoming.
yes, I'm sorry. I'm
No,
saying
you're
CUBE for
fine.
short, but it's
You're
conduct
fine.
unbecoming an officer. That is definitely a tier one policy.
Yes.
So just to, this is like a perfect depiction of the question you just asked, Joshua. So in this situation, just for those listening in, OPR's kind of approach was to encompass all of Officer One's conduct and the conduct unbecoming allegation. Whereas I split it up into the conduct unbecoming being the kind of professional or unprofessional interactions, and then the grand jury matter under the efficiency and cooperation.
Any questions? Okay, so when Dave and I looked at conduct unbecoming for Officer One, there was a kind of repeated pattern of engaging with other Arlington employees that in the interview where he, was walking through his own behavior, kind of acknowledged that he routinely, gets loud or gets profane, and that he tells the person that he's talking to that I'm not angry, or I'm not directing this at you, I'm just a passionate person. And I struggled with that because I don't think that excuses the behavior, and especially from a supervisor, that kind of regular conduct seems, unacceptable. I do think that I think that in a different case, we would probably file that under, personal contacts. But to me, the violation of the Supreme Court grand jury rules, where there was a normative policy, it's not, clearly written down, understanding that, I think from the circumstances and from the testimony he provided, it was clear that this was a kind of emotional choice to go into this proceeding despite, kind of sarcastic but negative feedback from the Commonwealth Attorney's Office staff, kind of blowing through the administrative layers there, and having a significant impact on other cases. This going in multiple officers at a time was not consistent with the normative informal protocol, and is kind of, the Commonwealth Attorney's Office kind of raised this in our preparation meeting last week, which is, there is behavior here that could have been viewed as jury tampering or obstruction of justice. And, so if that had been pursued by the Commonwealth Attorney's Office, this behavior would have been very much relevant to compliance with the law. So to me, the focal point for conduct unbecoming is the decision to go into a grand jury where you haven't been noticed, you have no reason to be there, and bring 2 other officers with you, where you're being kind of intentionally disruptive. And then on top of that, choosing to provide testimony that is so far outside, normative practice, or, that it negatively affects the other cases and requires the jury to be reconvened. Dave?
Yeah, no, I agree with that. I think the guts of the violation here is Officer One's decision to, even in his mind, sort of blow through the protocols because he was personally upset with the Commonwealth's attorney. And I think I can understand to a degree why he was upset with the Commonwealth's attorney. I think they've, even on the record, sort of admitted some failures in this case. I can understand why Officer Two was upset. As you said, Julie texted and emailed the Commonwealth's attorney about a case in which there was a guy who had to be pulled out of the car. The window had to be broken. He cut his arm. And I think there was a weapon found in the bag in that car. I don't think he knew that at the time, but I mean, a serious matter. If I was the officer, I'd be upset about that. I mean, he wanted to know what happened to the case, and they didn't respond to him. And I think the Commonwealth's attorney, as part of the investigation, said, yeah, we should have. And so, but I think those points need to be made up front, because the bigger point is, okay, you were frustrated with this, you were frustrated with the case, but that does not in any way excuse your, and again, I'll refer to what he said he was going to do in advance, which was identify the correct charges in his mind. The Commonwealth's attorney has a particular view of how she sees charging, and she was elected by the county. Everybody understands that she has the authority to do that. And he even said in his investigation, Officer One, that he prayed that he wasn't breaking the law. Okay, so if you're a supervisor and you are telling yourself, and even said, it's not going to work out for me. I think that was some of his language, like in his interaction with the Commonwealth's attorney, there was a little bit of flexibility, and our understanding of the process and the protocol for grand jury is that it's kind of an unspoken thing, and there's a little bit of flex in the joints in terms of exactly how, but no one had gone in with 2 or more officers at one time, never. So he knew, and he even said that after talking to one of the Commonwealth's attorney with whom he had this back and forth, in which both of them were using profanity, he said, basically, he thought to himself, this isn't going to work out for me, but I'm going to take a swing at it, essentially. So words to that effect. So that's not okay. That's just, to me, a significant crossing of a line, invading the Commonwealth's attorney's discretion as to how to charge cases. Individual frustration might be understandable, but taking that final step is significant. And again, supported, and I agree and support the ACPD's decision to find a sustained violation.
Other questions about the kind of conduct or the decision-making on any parts leading to a sustained finding? Does anyone want to move to adopt Dave's and my recommendation that we sustain the finding of conduct unbecoming against Officer One?
So moved to accept the recommendation.
I don't, it's totally up to you, version on it, but you may want to go at the end once people have an appreciation of kind of like what was broken down and what actions you're saying lead up to each part.
Okay.
Just in case there's any divergence of opinion as far as like what belongs in each category.
Yeah.
It's just my recommendation.
Yeah, that makes sense. Okay, we'll go back to the slide where we've got all 3 at the end. Okay. Okay.
That makes sense.
Is the board comfortable with that? If we vote on all 3 at the end? All right, let's move to personal contacts, Officer One. So the language here, employees will treat all persons with respect, will not use degrading, profane, or abusive or defamatory language when in contact with the public, toward other employees, or when in public view. OPR found this not sustained. IPA found it withdrawn. Do you have any color or commentary?
No, I'll just restate that I certainly found Officer One's conduct to be extremely unprofessional and not reflective of the professional brand of ACPD. The only reason why I personally thought it made sense to withdraw is because it felt redundant to the conduct unbecoming, since the conduct unbecoming, for my analysis, encompassed this same conduct. Again, the grand jury stuff, and I hear kind of in y'all's dialogue that I see why they kind of bleed over, because some of the kind of, sentiments and language as to, the why behind why the grand jury issue happened is related to the underlying conduct as well. But I just separated the two. So the efficiency and cooperation, again, sorry if I'm being repetitive, I just want to make sure it's not like getting mixed up in the organizational concept there. I withdrew personal context because I dealt with the professional verbal behavior under conduct unbecoming.
Albert?
I mean, we're splitting hairs here, but as I'm looking at this, perhaps withdrawn might have been a better outcome, but it's not sustained, but it's like splitting hairs. So for me, if we found it not sustained, but again, I'll go back to what I said before, like conduct unbecoming kind of covers this in the way that we view the incident. It kind of covers it. So yeah, that's pretty much it.
When we looked at conduct or personal contacts, I mean, I think because the basis of Dave's and my finding conduct unbecoming was to do with the grand jury, to use the example of kind of functional distinction, that, that was more, crashing a car into a building, and this is more, interacting with a civilian. And so we recommended that this violation be sustained on the basis of kind of meaningful accountability to different parties for different things. So, disruption of the kind of criminal justice process and, leading supervised employees down the wrong path, making a kind of intentionally emotional decision was the basis for the CUBE. For personal contacts, we have, interactions with witnesses, fellow county employees, where they walked away with the impression that he was rude, that he made jokes that seemed gendered, that he was patronizing, that he was demoralizing and mean, and in some instances profane. That for the accountability of reflecting on, how we behave in front of other employees and represent the inter-office, where, again, to Dave's point, we want to highlight that there were definitely actions by the Commonwealth Attorney's Office where, the breakdown of communication was, there were actions on both sides of that, but that and including profanity, but that the kind of repeated interaction that Officer 1 had goes to a functionally different kind of violation that there needed to be meaningful accountability for, separate from, something where the grand jury violation, in my opinion, and I think Dave, you can clarify, but I think that was sufficient to say, conduct unbecoming. This was like borderline, not in compliance with the law. It was intentional misleadership. And then here we're talking about a pattern of your behavior externally in a different capacity. And so we recommended sustaining the violation against Officer 1 for personal contacts to kind of make sure that there is meaningful accountability for the different facets of the impact of Officer 1's behavior and decisions and actions, not just the kind of all-encompassing. Dave, do you want to add?
No, I agree with that. I mean, there were separate days. There were separate days that Officer 1 interacted with the Commonwealth's attorney.
Okay. Any questions from the COB about this?
So I just wanted to clarify in the lunchtime incident and then the other one where Officer 1 was sort of trying to teach the law to the Assistant Commonwealth Attorney, you're putting that here. Okay.
Yeah.
I agree.
Okay.
Yeah.
Yeah. It seemed like two facets of two different decision-making kind of patterns, where one is about like, how do I lead my staff and how do I conduct myself in kind of the context of this criminal, the court grand jury procedure. And then to your point, like dealing with.
Making snarky comments for lunch.
Right.
Yeah.
Right.
So that's where you're putting that, and then where the OPR is putting it, I'm sorry, where I should say where IPA is putting it, where OPR is putting it that way. Not you personally, but where your roles are putting it is saying that you recognize that, but you're just rolling it up into the first charge.
Yes.
First.
OPR is rolling all of the underlying conduct into one allegation.
Okay. You're saying.
I would have otherwise rolled it into personal context. I chose conduct unbecoming because I felt like it rose above even the level of a basic, personal context of somebody's being rude at a traffic stop, because of the fact that he's a supervisor, because there was repeated behavior, because it was characterized as condescending, patronizing. It was more of a kind of way of doing business, if you will, and demeanor than it just like one specific, bad interaction or an argument or something of that nature. So it's, I think, just a matter of like, are you putting it under personal context or conduct? I think you're aligned in that with the conduct.
And then my last question is for those watching online, it's probably the first time they've seen Drawn. And they're probably wondering, oh, that's an option, that's behind door number 5. So if, from the point of view of your respective offices, how you come to the determination, not just within this fact pattern, but just generally speaking, when withdrawn is the proper course, and what does it mean? Does it mean that because there was some violation that was looked at, so it was withdrawn, signaling that, oh, we shouldn't have actually looked at this at all, or is it saying something different? So just from your point of view, because I'm sure you all would arrive at that differently. Whoever wants to go first.
So you go ahead.
Okay, because we might have a
Right, different way. Right, that's us. Right.
I think we're kind of all saying, citing to the same behavior as being, something that, we don't find to be, palatable,
Right.
Professional, what have you, and we're just slicing it up differently. For me, and when I look at an investigation or when we go into an investigation as like a collaborative investigative team, we outline what we think are going to be the allegations that encompass the underlying conduct based on the allegation. Then sometimes as you sit in on an interview and you start to listen, or you uncover more and more facts as you would with any investigation, things start to maybe shape up differently than what you originally thought. And so then you may look at the conduct and decide that it fits better under a different policy than what you had originally envisioned. Or it might be that you go into the investigation looking at it from several different places, not knowing which one is going to rise to the level of. So like personal context and conduct unbecoming, you might have gone into it knowing that some of it might overlap. But then after you hear all the facts, you decide which one is more fitting. And so one of them will get withdrawn and the other one will get, sustained or, become part of the actual formal allegation.
So the employee rights, which is a Virginia code, requires during an administrative investigation that you provide an employee written notice of the allegation that you are investigating. So in order for us to make sure that we're in compliance with that law, what we would generally do is especially with something like this, when we're not quite certain what we're looking at, is we may give out 2 or 3 allegations with the intended purpose to withdraw one, or several. And again, administratively and historically, what we've done is if there is a sustained finding for what I consider to be a tier 1 policy, right, as long as it incorporates the same sort of fact pattern behavior or similar things, then we will typically withdraw the others and go forward with the most serious policy allegation. Now, with that being said, that does not change the analysis of the recommended discipline. When we do that, and I know we haven't started talking about that, it is the incident and the fact pattern in its totality, regardless of what allegations were withdrawn, sustained, et cetera, or especially withdrawn, right? It is what actually happened, what took place, and then we'll make the decision, the recommended discipline based on that. So again, for us, withdrawal, we use that as a mechanism because we have to be in compliance with the law. That's number 1. Number 2 is I just want to do as a little bit aside, a little detour here, is that a citizen, when they complain on an officer, they can always withdraw that complaint. And that does happen. In fact, I dealt with that earlier today. After having a long, productive conversation with someone, he said, you know what I thought about it, Captain Kim? I'm withdrawing my complaint. You've explained a lot of things to me. I wish at this point to withdraw my complaint. You have every right to do that as a citizen. And of course, I always tell them, well, you don't have to do that. I'll still look into it. It's not a big deal. Like, this is what I get paid to do. But after that, they might be like, you know what, never mind. I want to withdraw. And so those are the 2 ways that we use withdrawal. That doesn't mean that we don't write it up. There's still a memorandum that's generated about this complaint that occurred. It just, we have to do less because this person withdrew their complaint. We will always ensure that we didn't break any policies,
Right.
Before we just simply take something back. But a citizen can certainly withdraw.
Is there a difference in that officer's record if something is not sustained versus something is withdrawn?
Yes,
Okay.
there is. And it's very nuanced. It's
Okay.
very nuanced, right?
Mhm.
It's nuanced when we start deep diving into something, right? Because, not sustained, and we looked at the first slide, what does that mean when you say not sustained? Right, I can prove or disprove. When you withdraw something, it means that, you know what, for whatever happened, it wasn't actually a thing.
Okay.
You know what I mean? So it's very nuanced, but you will only find that when you deep dive into something. So.
Just for some additional context, while the kind of definitions for sustained, not sustained, what have you, are kind of standardized across the board with police departments, this kind of way of determining how you go about assigning allegations and, how you stack them or don't stack them, this is a stylistic choice of each individual department. So there's not like a hard, fast, and right or wrong way to do it.
And we will get to discipline sufficiency for the sustained violation, but that was part of kind of our thinking was that, because these were two substantively different behaviors, that it would have been more meaningful to have accountability by, having them be separate violations, even though, this falls under CUBE, that, the accountability being separate.
I agree with that.
Thanks.
Okay. Oh, wait, sorry, we go back. Does anyone else have questions about the personal contacts officer one?
The only thing I might
Yeah.
add is that it would, and maybe I missed this in both the OPR report and Bobby's report, is it would be helpful to know, like, when you decided it was not sustained or withdrawn, that you're doing it because it's under, a different violation.
Yeah.
I don't think it was in there, but I could be wrong.
No, I usually will put it kind of right in that last little paragraph where I say, in conclusion for this reason. So on this one, it would be, just so you can look at, on page 6 in the first paragraph. I'm sorry, page 13. What am I talking about?
They
Page
are,
13 in the first paragraph.
they are long reports and we've been prepping for this case for a while.
Yeah, okay.
I was reading earlier. I had to
But yeah,
go back.
right, usually right before, like, you see the allegation, or the finding, and that's underlined, like the sentence preceding it will usually tell you like why something is, like a conclusion sentence for you to quickly be able to kind of get the point.
Good question. So something you just said, Captain, said 5 minutes ago when we started this allegation, was that in retrospect, maybe for the reasons that you put it in the conduct, underlying conduct, and conduct unbecoming, that maybe it would have been better to withdraw rather than not sustain it. So if in the context of personal context, we are talking about the interactions of the county attorney's office, Commonwealth Attorney's office, excuse me. Do you think that, yeah, if that had another bite at the apple there, that would be more accurately described as withdrawn rather than not sustained?
I don't know. It really is up to so some of it is I have to allow my investigator to have some latitude because they're the ones that are putting in the hard work. And as long as something is not egregiously out of bounds, right? So within like what we like to call 6 degrees of azimuth, I have to give them that latitude. They're the ones that are doing like the heavy lift of this. For my part, it's reviewing. Did we get all the facts? Am I keeping apprised of these things? I have to provide that latitude. So again, I believe that it's splitting hairs. As I go back and think about sort of what the investigator's analysis was with this and my own interpretation, I believe it's within that 6 degrees of azimuth. So this is a long way of me answering. I'll stand by what was done with this because that heavy lift was done by the investigator, and our report is incredibly long and thorough. So multiple witnesses were interviewed. There was a lot of work that was put into this, so I have to stand by what was done.
Okay, but to clarify again,
Yeah.
I'm not saying that, of course, you have to disagree.
Yeah.
I'm saying,
Yeah.
this was done under the auspices, your investigator, of course, did it under the auspices of putting it under a different, bucket, really.
Yeah.
And so do you think, speculate, that if you actually separated them out, right, and the conduct with the Commonwealth Attorney's Office was not part of your conduct unbecoming and was in personal contacts, that would still be not sustained? Or do you think that would change your investigators?
Can I reiterate what I think you're asking? Because I was just having the same question, which is if he hadn't gone into the grand jury,
Mm-hmm.
And so there had not been that at all. All you had was the fact pattern about the interaction with the attorney's office.
Mhm.
Would that have been you or personal contacts for you? Wait, Joshua, is that what you're asking?
That's a fair first part, where it's.
That's a hypothetical that didn't occur, so I don't want to, I mean, there's a lot of things that are nuanced, but you want me to separate out this sort of grand jury thing. Do I believe that the conduct that was done during these multiple interactions was professional or painted the agency in the best light? Keeping aside the grand jury, right? So there's just the interactions with the Commonwealth Attorney's Office.
Mhm.
No, I don't think that it was professionally done, and I don't think that it painted the agency in the best light. That being said, do I believe it rises to the level of a policy violation? I am uncertain of that, right? Because as I look at this thing holistically, as I'm required to do, that is not the fact pattern of this case. The fact pattern of this case is that grand jury interruption did take place, and I cannot separate that. So I do not know the answer to that. But what I'm saying is, I don't know. I can't give you a definitive answer whether I'm going to say yes or no, that that was a policy violation. Do I think it was professional? Do I think that it paints the agency in the best light? No, I don't. And I want to make that very clear. Those interactions could have been done better, 100%.
Okay, so for me, I think the grand jury is the crashing of the car, and the using profanity and being rude and demeaning to folks was the personal contacts, sorry. Oh, yeah. But like, I think that does violate the letter of the written policy about personal contacts. It says profanity, it talks about rudeness, it says towards the public or other employees. So to me, that's kind of where we came to the basis of our findings. Dave, is that your
Yeah, I agree.
recommendation? Okay. Okay. Yeah. Okay, so for cooperation and efficiency, this falls under duty responsibilities. An employee shall cooperate and direct and coordinate efforts in such a manner to establish and maintain the highest standard of efficiency in department functions. OPR found this not sustained. The IPA found this sustained for Officer 1. We'll review this for Officer 2 next. Do you want to speak to Officer 1?
Hope you had it withdrawn.
Oh,
Yes.
did you? Okay,
Yeah.
sorry. Yeah.
Right, because they, again, looped all the conduct together under.
Sorry.
So just without beating a dead horse, I
Sorry.
sustained it because I separated out the grand jury conduct.
Albert?
Yeah, we withdrew this. Yeah, and again, we're gonna go circular, so, yeah.
And I could just add, I mean, and I understand why you truncated it, but in a way, it was, Officer 1 was very, and Officer 2 to agree in the investigation was adamant that it was ironic that they were being, the allegation against them was that they were increasing the inefficiency and not generating cooperation because they thought that the Commonwealth's attorney had been inefficient. And again, I understand that, but I also think it highlights the real misunderstanding that Officer 1 had, because as a result of his decision to just pour down and take his, his individual view of the relationship, he actually did generate the requirement for the Commonwealth's attorney to represent the case, which is highly inefficient. And similarly, the Commonwealth's attorney had to notify other defense counsel for other defendants who had been before that grand jury. So it actually did result in some significant inefficiency. And I think, again, just goes to the point that despite the Officer 1 and 2's, frustration in their individual matters, that they took this into their own hands and created a larger inefficiency, in my view.
Yeah, I think our kind of discussion centered around the implications for the
Other
county.
cases.
Yeah.
Yeah.
Any questions on duty responsibilities for Officer 1? Right. Duty efficiencies, cooperation, and efficiency, Officer 2. The relevant policy language is the same. I think this was not sustained by OPR and sustained by the IPA. We went back and forth a little bit on this one because Officer 2 was led into this decision with his supervisor. And, you know, there was a normative policy where he and Officer 3 could have swapped under different circumstances, right? So like for Officer 2 to be the one who went and reported on his own kind of testimony, that would have, but, you know, the normative and the written policy don't establish multiple officers going in. The consequences of the disruption were significant. The frustration was definitely understandable, especially for Officer 2, who, as Mummy pointed out, you know, had sustained an injury and had kind of a vested interest in the case. And while he was led into the room by his supervisor, he also holds a supervisory title. And that in those roles, you have to, especially when it's difficult to make a hard decision, be a leader and kind of model the behavior that will help other officers make good decisions. So I think that was the basis of our kind of conclusion that this was a sustained allegation against Officer 2, where it is a little bit difficult, but ultimately, if you're being entrusted with a leadership role, including supervision of other employees, that you have to be able to model good behavior in difficult circumstances, knowing that this was not the right choice to go in, all three of them together, and then to stay in while testimony that was so far outside of normative policy or, you know, the written procedure was being given, to kind of stick with that. Dave?
Yeah, no, I agree with that.
Nice question, actually.
Yeah.
So it doesn't sound like it's typical to brief officers in general to understand how grand juries work, how the process works.
It's not typical to brief them.
Oh, to train them, for them to know exactly.
There is training and there is kind of mock kind of going through this, and the normative behavior is to go in and read your report and then answer questions that
Well, but
the
even
grand
the
jury
cases,
asks to you.
I mean, okay, I think that common sense would have suggested to you that you should. But are they actually, do they get training that makes clear exactly what the process is and why, you know, like that, like you don't, like 3 people don't go in, you can't do it that way. It's secret. You're not supposed to be there. What's the else? Because I just find it surprising that they didn't.
I think ACPD acknowledged in their report that there needs to be more clarity around what the expectations are so that officers have that explicitly. But it was my understanding from our last conversation where we were looking at the training that they have training about how to participate in grand jury.
I remember that. I was just more curious about.
And that was the other aspect, is like, if officer, you know, for Officer 3, she's early career, she's never done this before, you know, she's kind of following where she's going. I don't think that she had any real provision or ability to, but Officer 2 is not only seasoned, but in a leadership position, has done this before. Do you guys want to speak to training?
Yeah, a little bit. And I just wanted to touch one thing up front. Officer 2 is not in a supervisor. So I just wanted to clarify that it's not a supervisory position. As far as the training, you know, and this is an area, we've talked a little bit about our new training section, but the training that our officers get is really moving. It's one day and it's in the academy. So there's clearly a need for us to add this into our initial, you know, the training that we do after the academy to help people understand the grand jury and what its function is, what your role is. Because, you know, when you go to court, you're there's a judge, there's a prosecutor asking you, you're just responding. You're told when to speak, what to talk about. Grand jury is very different. So there's definitely a need for us to add this in our training following the academy, because what the academy is a day of moot court, and you know it's not really complex. I mean, it's one day. So each officer might get a 1 or 2 shots at testifying. So there is a training component there that we've already talked about adding into our, you know, when the officer is done with the academy before they go to field training. Equally, there were some policy things that we need to tighten up. We have changed our policy around this. You know, the new policy will require that if I switch with Albert, I can't go to grand jury and Albert goes free, we will notify the Commonwealth. That's never been a policy or a rule. But that needs to be in policy, it's been put in policy. So, I think that's another just important thing there. And, I just wanted to talk a second about the rules of the Supreme Court and the handbook for grand jurors. And I've never seen those documents before. And is that good or bad? I don't know, but I've never personally seen them, and I've been doing this 3 decades. So, I think there's room there that for some of those things we may have. There may be other things we want to add to policy, because it's, from my point of view, it is unrealistic for me to expect our officers to have read the Supreme Court rules and the grand jury. So that's more on us to make sure we're taking care of that piece. So we've already, been talking about the training piece. We've made some initial changes we've already pushed out on the policy, but if there's other things that, we need to add, we're certainly willing to do that. But those are just things I wanted to clarify.
Okay. That's my mistake. I guess what we were talking about was that he had a senior ranking title.
Sort of a leadership role. I mean, I don't know the exact parameters of, I don't want to say the word, but like it must.
He's more tenured than Officer 3. That's it. That's just more tenured, and probably has done that a couple of more times.
Title that.
Yeah, but that's not a supervisory rank. So that's not there are many people of that rank at the agency. So, and they are not supervisors. There's minimum qualifications in order for you to obtain that rank, but they are, I think you can get that rank after 2 years of 3 years. So, yeah, he's just more tenured. That's it.
That distinction important for why it was not sustained for efficiency.
For us, the relationship between Officer 1 and Officer 2 is more substantively important. And the not kind of what Chief Penn alluded to, which is the obscure nature of the Virginia Supreme Court handbook on grand juries. So, I discovered that during my research for this particular case, and it was not something that I just had laying around on my desk. I had to find this thing to see if there was written. And I'll be very honest with you. When this case was first presented to us, I didn't think there were any rules about the grand jury. And in discussing it with people that have just as much tenure as I do, they're like, are there even any rules? We kind of scratched our head and like, I've never heard of any rules. I've never seen these rules before. Are there rules? Like, does anyone know of any rules? And then it was and then was the research to be like, are the rules written down anywhere? And I guess if you were an attorney or something who practiced criminal law all the time, then you would know these rules. But as police officers, we have to know many, many things. And this is just not something that has come up. And I cannot just emphatically say enough how obscure this thing is. It just was obscure, but shame on us. It needs to be tightened up in the policy, and that's what happened.
So it's really a matter of, to your point, like 1, to your point, Officer 2, led by Officer 1, and then 2, to your point, reason to know. And you're like,
no, clarity. And does Officer 2 realize that by doing this, there could be this potential fallout? And the answer is no. Clearly, in the interview that the investigator had with Officer 2, there is a light bulb moment that goes off after the investigator tells Officer 2, this is what happened as a result of what you did. He's like, oh, okay. You know what I mean? Like, I'm telling you, we've delved and opened up into something that we've just never had to deal with before. And we are dealing with it. I just want to make that very clear. And we did address it. So, and that's a long way of me sort of explaining. This is the reason why this outcome is because of the relationship between 1 and 2, right? Not that 2 is a certain whatever, but it's the relationship there. And then the clarity around what you can and cannot do. Those two things intertwine.
So I sort of struggle with that second line of reasoning about, reason to know. I think that, with the emphasis that's been placed on how secret that testimony is, that like you couldn't have secret testimony if you're testifying in a group. I mean, there's like a pretty famous joke about being able to keep secrets. Like, I think the normative policy was clear enough. And I think that the circumstances leading into that decision were not like, if they met and said, we're unable to get in touch with them, why don't we all go in there together, and she's never testified, you're going to be doing it, and I'm going to be there to make sure that it's clear that this is okay, right? That wasn't how we got to this point. We got to this point by going and kind of haranguing the staff and saying, I don't like the outcome of this, so this is what we're going to go do. And then in that opportunity, there was occasion for Officer 2 to say, I don't think that we're supposed to go in there together. And I don't think that going in there under these, like, I hear what you're saying. The policy was unclear. The normative policy was a little bit informal, and I follow that. And I don't know that they necessarily explicitly knew that you couldn't go in multiples, although I think it seems part of the whole process that, like, you shouldn't have to bully your way past the person with the cases at the front gate. Like, we're kind of plowing through procedure here and going along with it. And I think, I don't know, the supervisor level thing does kind of change my thinking a little bit about being led by a supervisor, but I struggle with the idea that I think Officer 3, who's junior and who's new, who's like, I gotta go. I mean, what am I gonna say? What am I gonna do? But Officer 2, having this frustration, is making similarly kind of emotional decision, not being clear-headed about, is this what I'm supposed to be doing? Is this going to be conducive to, the highest standards of efficiency in department functions? That does seem like it was not good decision making and not consistent with the policy from my perspective. But I acknowledge that the more important takeaway here is to clarify and make sure that folks understand how to interact with the grand jury. It sort of feels a little bit like hot coffee to me. Like, we're going to make a big deal and change policies and change training so everyone knows not to go into a grand jury in multiples. And I suspect that isn't really necessary for officers to know that this situation was not the right decision path, whether you're with your supervisor or not. That's kind of my takeaway for Officer 2. Yeah, Selena?
And the right decision path was, I'm not sure if I'm allowed to do this task, right? Like, that's what they should do, because this fact pattern might not come up again. This seems rare.
Well, or the Commonwealth Attorney's Office staff saying, that's not how that works, or good luck, or whatever.
Yes, and also it is good that it is being done, though, because if it does come up again, now it's not, especially in a process that you will run, the due process procedures that the officers are afforded is much better to be able to point to the clear rule than the pattern in practice. So that is a good thing that there is going to be now more there, but yeah.
I just want to highlight a couple of things to shed light on my finding here, my perspective on the case. So I think that the bigger impact for me was not necessarily about the number of people in there, but the substance of what was said. It was a clear, conscious effort to overstep the authority of the Commonwealth Attorney's Office and take matters into their own hands. I certainly do agree with the underlying principle that, like, a supervisor has higher culpability and should have, in this situation specifically, said, we're not going to handle it this way. We're going to do X, Y, and Z. I do, though, distinguish, a situation where someone is going to a supervisor kind of like unknowing of like what is the right or wrong thing to do, and then their supervisor like leads them astray, versus I want to go in there and do this, and then the supervisor is just like, oh yeah, I'm going to go ahead and lead that up. There was definitely, from what I gleaned from the investigation and the interviews and Officer 2's own testimony, a like willful decision to engage in this conduct that's very starkly different from Officer 3. And so my take on that would be to hold both officers accountable, but obviously the accountability may look different for a supervisor versus the underlying officer who's subordinate to that officer. I wish that Officer 1 had just completely, disbanded this whole thought process and said, like, we're going to handle this differently. But instead, Officer 1 kind of orchestrated the whole underlying planned, and they literally planned it beforehand and then went in there and took the steps to you know, make to do the testimony that they did. I did not hear any sense of like remorse or kind of introspection from either officer. I do think that there probably was some sort of like lack of maybe, first of all, let me just say this, there was certainly a lot of mitigating reasons why they did what they did, and I'll continue to say that. But as you know, Dave said, and I agree, it doesn't excuse it. I think that officer two, and perhaps both officers, I think it's fair to say, may not have understood what the impact of it was going to be in terms of having to reconvene the grand jury and you know how it might impact other cases. But it to me does not negate that they went in there with the intention to kind of disrupt the process or take matters into their own hands. And I do agree that there was some kind of a lack of clarity around like, you know, what the process would look like. But I also do recall that during our training, there was still some very clear kind of language in the code around just kind of what the roles are, right? And the underlying takeaway was that it's the Commonwealth Attorney's job to advise the grand jury as it pertains to the law, and it's the witnesses, in this case, a police officer's job to advise the grand jury on the facts. And not necessarily to, you know, for those things, it's not intended for those things to kind of, you know, overshadow one another, to intersect. So I do think that there is some clarity in that regard. And if there was any shadow of doubt, which here the preponderance of the evidence is the evidentiary standard, which is more likely than not. My takeaway from listening to the interviews from both Officer 1 and Officer 2, but it's more likely than not that they knew going in there that what they were doing was inappropriate and an overstep of what they should have been doing. And so for that reason, I sustained, even with, you know, me agreeing with a lot of kind of what OPR points out as their reasons for their not sustaining that allegation.
Just want to add 2 cents here because I asked the question to clarify why OPR kind of did what it did, because I do want to understand it, and I do. I understand that perfectly well. I think that the difficulty I'm having trouble with it is, in addition to what Mummy's saying about kind of the pre-planning, this is on page 6, Officer 2 himself said that he went to the grand jury to testify to the charges that the defendant was arrested for, not for what he was charged with. And that he wishes the Commonwealth Attorney's Office had an auditor to hold them accountable for how they handled their cases. If that officer realizes he's not the Commonwealth Attorney, he doesn't have that authority, and that's not his job. And I think that's kind of my concern, because if you get that, that's seemingly all you need to know. So far as these are the things that the grand jury is considering, and if I go beyond that, you're acting outside the scope of your job. And I think that's kind of my concern with it. Again, it's kind of like Charles alluded to, it's better obviously for people to have policies. It's like, and it's better for those things to be clear. But I think that my concern is kind of taking that totality approach when we look at the other conduct, especially towards all the officers. There's not, you know, and I'm to come in here, there's not anything here. This is the efficiency and cooperation part. And if I know that grand jury is looking at A and B, and I'm like, yeah, but I'm going to give them A, B, C, D, E, because I feel like somebody should hold these people accountable. That's going to be me today. That to me is kind of the problem. And that's why I'm thinking, okay, well, I'm having difficulty with the not sustained. Take that with what you will, but that's kind of my perspective.
Yeah, that's helpful. Thank you.
One thing I want to add, you know, and it is the pattern, the norm is one person goes in, but I don't want people to think that it can't be more, it can, 100%.
Oh, it's written down. That they'll testify one at a time.
Well, I've never, I mean, maybe I'm gonna.
It's not the norm, I just don't want it to be like it's an absolute bar, because I was involved in a case years ago, and I'm sure you insisted we both do it.
A judge can, so just so you know too, if you talk to a judge and if you are not listed or as a witness for a specific grand jury case, you can proffer to the judge, Judge, Your Honor, I would like to testify in front of the grand jury in regards to this case. That is 100% within the rules of the handbook. You could theoretically proffer to the judge, in addition to that, I would like Officer X to come with me because we both have information to provide. So
I just wanted to point out, I mean, it is the norm. It's usually one person, 100%.
should be,
But
should
there-
be, should be.
Yeah.
Should be.
Yeah.
Should be, not shall be, which is different, right? So I'm looking at should be, not shall be. And there is a difference.
Right, they did not get sworn in by a judge to go in to the.
That is correct.
Yeah.
They got sworn in by a clerk, but they did not proffer to the judge, Your Honor, I would like to testify. They skipped that step. So, and that's why we are here, what we are here today, 100%. So,
Okay, I think that's what we need to vote before doing discipline separately.
Yes, I did want to just highlight the one additional thing for me that I talked about in my analysis or my report is that it would be my recommendation, my formal recommendation, that in situations like this one where you have a supervising officer who's involved in the underlying investigation, that there should be a separate supervisory analysis for that officer. There is a supervisory code that we actually, I think, talked about maybe during supervisory training that we did last time. There's a minimum of 300.55 supervisory officers that goes into detail about what the responsibilities are of the supervisory officers. It is my understanding that that's not like that's more so, and correct me if I'm wrong, Albert, designed to kind of give some kind of direction to what the role is, but it's not used in like a disciplinary context. So I don't know if it's this policy specifically that's used, but just what I would like to see is a practice of a separate either allegation or at least at the very least a separate analysis as it pertains to supervisor, to include an analysis of whether or not that officer should continue to serve as a supervisor, or if the supervisory role should be modified or terminated or not, and for whatever reason. Which probably is a good segue into the conversation.
I don't want to have that until we vote on the tally, so I'm gonna go ahead and ask if the COB wants to re-review or refresh on any of the allegations. We'll go back up to this summary slide just so we can look at. I'm gonna go a little bit out of order that we have there. I'd like to vote on all three for Officer 1 separately, but we'll take 4 votes. First one will be Officer 1, conduct unbecoming. The second vote will be Officer 1, duty, responsibilities, efficiency, and cooperation. Then Officer 1, personal contacts, and then we'll do Officer 2, duty and responsibilities. Is everyone clear on that vote?
Is there necessity for us to do anything with regard to Officer 3?
No.
Okay.
I don't think so.
Okay.
I will just clarify, it's gonna take me a minute to record the vote. We were offered, or we were told we would have administrative support for this meeting since we're still short staffed, but I gotta record who votes what. So I will hear a motion to vote on Officer 1 for conduct unbecoming.
So move.
Second? Okay, all in favor of adopting the recommendation of sustained violation for Officer 1 conduct unbecoming, say aye.
Aye.
Aye. Okay. Opposed, abstentions? Good. All right,
And for those watching, Chair Evans said this at the beginning, I'm a new member. I'm not voting at this meeting. That's why I'm not participating.
thank you, Petra. Okay. Officer 1, duty responsibilities. Do I hear a motion to adopt the recommendation that we sustain duty responsibilities, efficiency, cooperation for Officer 1? Second?
Second.
Okay, Anika seconded. All in favor, aye.
Aye.
Those abstentions, okay. All right, for Officer 1, adopt the recommendation of sustained violation, personal contacts. Do I hear a motion to adopt our recommendation?
So moved.
Second. Wonderful, Selena seconded. All in favor, aye. Okay. Abstentions opposed. All right, moving on to Officer 2. Does anyone have questions before we vote? Officer 2, duty, responsibilities, efficiency, and cooperation. Do I hear a motion to adopt our recommendation? Which was to sustain the allegation of violation against Officer 2 for duty responsibilities.
So.
Okay, Dave moves. Do I hear a second? Oh, Anika. All right. All in favor of sustaining the allegation, sustaining the violation of duty responsibilities against Officer 2? Aye. Any opposed? Any abstentions? Yep.
I'd say this one's a difficult one.
Yep. That's why we made a cute little spreadsheet so I can track. Okay, thank you. Let's take a break. We are, I think, 10 minutes overdue for a break, and then we will come back for, well, do we want to do discipline and then we can do shares updates?
You guys.
Okay. Yeah.
Yeah.
Sure. Does anyone need a break?
And then I will also just say that, if there are any, after you guys go, any kind of residual, overarching questions about policy related to this investigation or other investigations or what have you, can always raise those during open discussion to talk about separately from, this particular investigation.
Okay. All right, we will go down to disciplinary sufficiency. So the discipline issued for Officer 1, conduct unbecoming, was kind of within the median guidance for a first offense, and at the low end of a second offense, but not the maximum for a first offense. ACPD also recommended that Officer 1 sacrifice leave rather than serving the hours as a suspension. We noted that aggravating factors, he was a supervisor. He certainly had, he was certainly expected to exercise better judgment. He had enough experience to know better. Mitigating factors, we acknowledge the frustration by the case-specific circumstances and that the grand jury policy is informal, not well documented enough that officers can easily reference it. Our assessment, here kind of thinking about, accountability and public trust, that we had multiple facets of kind of different behavior, but in disciplining Officer 1 for a tier 1, policy violation, that, a continued supervisory role, given the, experience of having led someone into, a bad situation, didn't signal accountability to the other supervisors who are looking at this behavior, that the recommendation to Officer 1 to substitute leave didn't signal accountability to the broader officer pool by not being there to signal that was, being held to account, and that the that using CUBE as a kind of umbrella for all of this different misbehavior, and then if that's the umbrella, and then choosing the median discipline for a first offense, when what the rationale provided was that this is kind of the encapsulation of multiple offenses that are tier 1 offenses, then not choosing the maximum discipline doesn't really signal accountability to the complainant or the community in terms of disciplinary sufficiency. Dave, do you want to add or clarify?
Yeah, I'm not sure there's multiple tier. I mean, if the grand jury is right, that's in my mind, that what, for me, and I know that Tommy has a slightly different view, but that the personal contacts and efficiency are separate, but they're not tier 1. So,
Right. Yeah, okay, that makes sense. Are there questions about disciplinary sufficiency? Okay. Our recommendation then being that this was not sufficient to hold Officer 1 accountable for kind of the different facets of how this behavior negatively impacted community and public trust. If there are no questions, I will hear a motion to adopt our recommendation that discipline was insufficient.
I guess the question that I would have would be with regard to what is within your possibilities for any sort of disciplinary action for a supervisor. Is it a possibility to be a supervisor, but limited in certain capacities as a disciplinary action, or is it an all or nothing? Like, like, so you're a supervisor, we want to discipline you in your role, you're a supervisor. Is our only action to not have you be a supervisor anymore? Or is there a possibility of having reduced responsibility still within your supervisory capacity?
Not reduce responsibility.
Right,
you know.
it's you,
You know, if
You are
if
fully-
it doesn't rise to demotion or.
Right.
I mean, no, the responsibilities in a given rank position.
right, you can't just cleave off. You can't do that
Can't
part
carve
anymore.
parts out.
Okay, it's all or nothing.
Mhm.
Okay, that's good to know with regard to.
Oh, I'm sorry. So is the question that you're asking whether or not there's something between these two things?
Yeah.
There's something between these two things.
I mean, you asked a very good question, which is, if I am a certain rank and I'm responsible for these 4 things, can we take number 4 away? The answer is no. There's no way to do that because not everyone is going to know that number 4 was taken away from you. You know what I mean? So, I mean, that's going to be challenging from an agency perspective, like an employer perspective, from the way that people interact with you, because they're not way that you should be figuring out how you should respond to someone who asks you for authority to do number 4. But you're like, well, wait a second, is that number 3 or number 4? And I'm just using this as an example. And so I think you asked a very good question, which is, can we carve away number 4 out of 4 things? And the answer is, there's no way to do that because your rank signifies a specific set of responsibilities and authority to do certain things.
Yeah, that's right. To take away supervisory.
Well, the recommendation was really to consider it, that it wasn't considered, and in doing so.
Because I mean, this was bad. I mean, this was bad. There's no question. And of course, as a senior person, you have to take way more responsibility. But there's been a lot of frustration voiced to me from ACPD officers about the Commonwealth attorneys. And I haven't asked them about it. It's just, so there's something going on that's an underlying tension.
So I want to just set up the conversation for success, because I think that there is a clearly identified kind of friction in this instance and in some regards. I think that we can't speak in this meeting to the larger relationship between 2 offices. I think that there are.
It's not our place to
Right.
give recommendations about how they fix
We
it or
heard-
any of that.
We heard significant and detailed kind of frustrations from both sides. And I think in your report and in OPR's report, kind of commenting on what would be constructive, I think that is sufficient. That's
Yeah.
outside of our purview. I think what I heard in the interview, right, from Officer 1, and to Joshua's point, kind of about Officer 2 as well, but to Officer 1, that like there was a mentality that, because I so disagree with something that was pretty explicitly political, outside of my jurisdiction, not my job, not my authority, but I'm so dissatisfied with it. And the frustration, pieces of the frustration, the communication being material, but other pieces of the frustration were personal grievances and political opinions that were used to justify a decision in a leadership capacity to go and disrupt, a very formal criminal justice proceeding.
So I'm not in any way arguing this wasn't really bad.
Right.
This was really bad. I'm just saying that there's a larger context of, I don't know what, miscommunications between the 2 that's part of the background fabric of, which doesn't excuse anybody. I'm just saying that he didn't get up one morning and say, like he's never thought about this, or it's never, there isn't some underlying tension. But just this morning, I decided that I really hate these people. So I'm really going to cause serious trouble.
Yeah, I mean, I'll say I think the 3 kind of pieces of accountability here that I think are insufficient are each individually, worth more discipline than was metered. But also, I think that that continued tension or that sustained, sentiment, like there were specific elements from the Commonwealth Attorney's perspective that had been meaningfully addressed and still did not speak
Yeah,
to.
no, I understand. I think there's just a cultural difference between the two. It's just underlying cultural difference. It's always gonna be difficult. I don't know. I'm just saying that taking away supervisory duty seems.
Well,
You're talking about-
what I'm talking about is that if you're looking at what that was, that like the maximum offense, the maximum discipline for a first offense would have made more sense to me than the median, because you're talking about multiple different behaviors.
Yeah, over
Including
several
it-
days. It wasn't just like 1 minute, I just got really mad. No, I get you. I do.
To clarify, would you
I
be
don't-
like
It's just,
opposing the recommendation that it be looked at, or would you be opposing, like, if that was the recommendation to take away supervisory responsibilities?
Well, our recommendation is just, our vote is whether or not the discipline meter was sufficient.
okay, that's
To be
fine.
clear, it's
You're not recommending
Yeah.
a specific something else or
I feel
anything.
better. I
Right.
think you're right. I just, the idea of necessarily taking away supervisor just seemed a little.
Can I
It
just
was-
kind of some context too?
Yeah.
Continued supervisory duties, does that mean like, or does that mean like for 10 days?
Yes, right. Is it temporary? Is it forever? I assumed it was forever.
Then I'm totally.
Oh,
I
no,
assumed
what
it
I,
was forever.
what I'm suggesting is that not being removed from service to signal that you are not, that you are being held accountable for this supervisory responsibility is an inappropriate metering of discipline where,
But again, the recommendation here isn't. for
Yeah,
anything
okay, that's
specific.
fine. So I misread it. It's fine. I thought that was the actual recommendation.
It was, yeah, good thing, yeah, it's good to ask. I think, yeah, because
No.
like, what exactly are we saying? Are we saying not sufficient and this should have been it? Or are we just saying not sufficient? Oh, and by the way, guys, these are the 3 bullet points that were in our head as we were thinking of what we're actually voting on, which is is sufficient or insufficient.
and
That's
that
what we're gonna
a
look at.
supervisory kind of assessment here was not conducted,
Right.
right? So that contributing to the insufficiency, but that you're not signaling that this person is being held accountable by recommending that they take, sacrifice leave rather than serving a suspension where, people at different levels see that there is meaningful accountability for these behaviors.
Can I just add a little bit of context too, sorry? Just to kind of frame the dialogue and give it some take a step back and look at it. When you're talking about sufficiency of discipline, right? We only see a small universe of instances. So I personally, it's my professional opinion, unless I see some clearly overly lenient discipline or some clearly harsh discipline, that because I don't have the broader purview to know how does this line up with other people's discipline? Is it in line? Because there does need to be some consistency, right? You don't necessarily know the full scope of this particular officer's disciplinary history or what positive attributes this officer provides as a supervisor to be able to make a full assessment of how you weigh the pros and the cons. So in that regard, especially where something is in the median, I'm going to defer to the police department in terms of utilizing their judgment to look at the big picture of how does this align with other things in our, professional standards and how we want to communicate that to our police department for the number of hours. Because I think slicing that up isn't necessarily getting us to our bigger picture of what we're trying to accomplish here, which is these cultural shifts, accountability, transparency, X, Y, and Z. I think for me, the bigger issue was not necessarily the number of hours, but more so that there should have been a supervisory analysis done. And it should have been a consideration, not saying that there wasn't, I'm just saying there should be one done in situations like this. But without knowing kind of all of the factors that go into that supervisory analysis, based on this investigation alone, I have serious concerns about whether or not this officer should be continuing to serve in a supervisory capacity. Doesn't necessarily mean it's terminated forever. Maybe it's, temporarily or whatever, but you'd have to know that person's full portfolio, I think, to affirmatively say one way or another what that should look like. And so I think that is just the area of opportunity in terms of just being maybe better informed to, like, for us to be able to truly like contribute to that analysis, or to know kind of what that analysis looked like in the form of a report, so that we could say, okay, well, they considered X, Y, and Z factors and we agree or disagree. But there is a certain level of this that, you know, first of all, we're giving our opinions after the fact, after the grievance process is already done. So it's just an additional level of accountability, additional level of transparency, but I don't think it's necessarily, with the way things are set up, you know, at this stage in the game, beneficial for us to be like getting that specific about, you know, how many hours or how long should the supervisor have been taken out of this role, or what should that have looked like? But I think it's a broader discussion about how do you make these considerations when you're looking at an officer or supervisory responsibility? How do you look at that accountability differently than a regular officer? That's what I would hope to glean from this conversation.
I appreciate that, because I think that's what was in my head. It's really hard when you don't know if this person's ever been disciplined before, like in a hothead, you know, maybe, but we shouldn't be guessing, like maybe not. So it's really hard when you don't know.
And I think the other point that I just want to highlight in what you said is, you know, there is consistency across the department, but like not even just this person, but like similar offenses, and that consistency. To me, the part that feels insufficient when we're looking at, you know, where are we signaling accountability to other supervisors, to the officer pool, and to the public, that for such an egregious tier 1, you know, violation, that you be asked to sacrifice leave rather than service suspension, where being kind of taken out of service. Now, I recognize that ACPD has, you know, staffing challenges and in a senior leadership role, you know, taking one person out, but that also is the organizational accountability for having people in those limited, really crucial roles be able to make good decisions and say, my politics aside, my emotions aside, I will consistently execute good decision making. And that to me is kind of the core of the sufficiency question, that there are kind of 3 facets of where, by saying it's fine, you can just, you know, give up some vacation time instead of being taken out of service, that's to me the like functionally important thing here is, if we're not organizationally accountable for, you know, these bad decisions, you know.
Okay, I can totally agree with that. Like, you know, potentially a limited suspension or something like that. No, I get you.
The cost of that too is what message it sends to
No,
officers that
exactly.
report to that officer or other. Correct.
Right, and everybody, I'm sure at this point knows what happened. Right? I'm
Well,
sure.
that's not true.
Oh, nobody knows what happened.
No, not everybody, not nobody.
Come
I
on.
think one of the things that concerns me is the focus on sending a message. When there's disciplinary action, that's a personnel matter. We're never going to speak about it inside the police department, because that's somebody's individual and private business. And the discipline is focused on correcting the behavior, ensuring the behavior doesn't happen again. And I don't think it's fair to say there's no supervisory review, because you don't have a document for that. That's true. We can't write down every conversation we have. We spend a lot of time on discipline. There's a lot of conversations on discipline. And, you know, we look at, you know, the person's whole body of work. We look at exactly what happened in this instance. We look at the progressive corrective action guideline chart. We look at what have other people gotten to make sure we're being consistent in our disciplines. It needs to be, if Officer A does something in this part of the agency and B does something over here, they should get something similar unless they have a different history. So, you know, there's a lot that goes into these conversations. I just wanted to share that because I don't want it to seem like we just pick a number and say something. Is that the statement that no supervisory reviews conducted, I just don't agree with that. I mean, we have a lot of conversations about how to correct that behavior, how to move the agency forward, how to make sure we're all performing at the best that we can be. So I just felt it was important to add that part.
So when you say that, do you mean that,
I'm sorry.
that no supervisory review was conducted, generally speaking, or do you mean none, you disagree with the fact that one wasn't actually conducted per some sort of policy and rule, some formal process? Like, what are you disagreeing with, that you have that
A
you all
comment
been
that there was
just
no-
generally look, okay, that,
Just the
Okay.
comment that there was no, I got the impression no supervisory review. I mean, when when an investigation's over, it goes to the chain of command. There's a lot of conversations about what is the appropriate thing to do, consider all the different factors, you know.
So you're saying
and so-
informally, these things were done. You're saying that, but
Yeah, there's no
formally they weren't
document.
done,
We
but
can't, we can't write
informally
down
they
every
were done.
conversation. Yeah, we'll
Right.
never get anything done.
I can assure you that they are done, they were done, they were done multiple times. And so, and the, you know, I do want to say, I think there's a focus, and thank you, Mummy, for bringing this up about like sort of what the actual discipline was. And, you know, is it in the median? I assure you, it is not, although it appears numerically maybe in the median, it is not. Because there are many things that come in between 0 or, you know, that level and where we're at. That is not what I would consider to be a median level, you know, outcome for this. It's just not.
So within the
So,
guidance.
I understand that, but what I'm saying, although it appears that way, and I could see why you would think that, but it is not. It is not, because there are low levels that are much lower. So, you know what I mean?
For
Like,
example, if it's in a letter.
correct, which is, yes, so when we.
For first offenses.
Yes, so I just want to make sure that and again, it is your recommendation, but when this analysis was done, and I should start with this, which is nobody in the agency is okay with what happened. So Lisa, to that point, not okay, not okay. No one is saying that what happened was okay. That needs to be addressed. That's addressed through multiple different ways. One is a policy correction, because the agency has to take that. Hey, we have identified a policy gap and we better fix this. The second is with the employee and making a determination about what is consistent and what is, you know, what is the best, I guess, most appropriate level for this particular action based on what has happened in the agency in the past, which is what, you know, kind of what the chief alluded to. If it happens with X, it has to happen with Y. We need to make sure that we are consistent and hold that individual accountability. And maybe, you know, I know there's arguments to the contrary to this, but I get it. This did not occur again after this particular incident. We made sure that this did not occur. And we can think about how much time has occurred since this incident occurred and where we are today. There's been many years that have passed. It has not occurred again. And I assure you, if it does, it will be addressed with the policy corrections that we've made. Okay, but there are some mitigating factors here that the agency has to take on its side about this policy, you know, thing that we needed to fix. But, you know, I do believe that this was sufficient based on what happens. And it is in no way, shape, or form, I assure you, the median outcome of something like this occurring. It's just not.
Can you speak to the recommendation to make it leave instead of a suspension?
That would be me. So how that works, first and foremost, one thing with Albert, just to be clear, OPR is would never do that supervisory analysis. What they would do is when we come back with a recommendation from all the conversations through that chain of command, depending on where that person is in the chain, from that conversation, I'm going to go back to him and say, hey, is this within the guidelines? Is this fair? Consistent across the board. So OPR as being the fact finder to the investigation, they're not part of the recommendation for what the actual discipline is.
Mhm.
Okay. I'm sorry.
Out to your point, so I think like what the ask is here is that, and just to be clear, I don't think, we're not saying that there wasn't a supervisory analysis done. Like, yeah, for all we know, there was one or there wasn't one. We weren't privy to that conversation. I think in a typical investigation, you have the investigative report, and then you have attached to that, some sort of documentation of kind of what the disciplinary kind of considerations were, going up from that person's like direct supervisor all the way back up, and what the recommendations were. I think that would be a place where it would be appropriate to maybe add some additional kind of context for, what was considered in terms of whether or not in this disciplinary context, a supervisor's role was, should be, terminated, modified, whatever, term you want to use, or suspended. that would give us the kind of lens to know kind of how you approach that analysis. And that's what we're saying was missing from this investigation as far as what we have purview into. So I think it's more of a, at least for me, it's more of a recommendation than it is, because I feel like without that information, it's hard for us to make a true kind of judgment about what that assessment, what the sufficiency was of that assessment, right? I agree with the overall sentiment. And that's why I also said that it was insufficient because it was not clear that that was or what considerations were taken in, because this was such a serious infraction that needed to be, something that was like clearly kind of taken into consideration, also given the multiple instances that happened that led to the underlying sustained allegation. There was one other thing that I was gonna,
I was just gonna ask, I think you were gonna speak to, the recommendation did not come from OPR, but it did come from ACPD. That the suspension be served as sacrifice leave.
Right, that comes through the chain, through the deputy chief, the recommendation to chief. So that comes through my chain in this regard. That's what it for to be just that, because of a lot of factors. One of the things I wanted to address was the aggravating factors, being a supervisor, enough experience to know better. I think he just gave me the prime example of 3 decades and being the chief. No one was actually sure what that actually said. We didn't have that document. So.
But he knew what he was doing was not right. I mean, he was going in there for the wrong reasons.
I'm not saying that. What I'm saying is, in the fundamental sources of just asking us the basic question, it made us all scratch our head. There was not a clear delineation to that. So I don't think in this regard, being aggravating, being all the years of experience, and especially when the chief says that he had an opportunity to actually do this with someone else, I can't say that's, to me, I just wouldn't consider that piece to be part of, in that consideration of the discipline. That was not a consideration that aggravating because he's been here X number of years, or that he's even a supervisor, because it had never presented itself. Neither was it in writing for us. Well, it didn't make you feel good, and I will say that, but pointing at that right place to say it's right there. Yeah. And I just think that was more of the concern for me, just right off the bat. Yes, Lisa addressed the fact there was an emotional exchange go along with it. Not excusing any of that or making any excuses, but when we all hear this and we're sitting there going, it's not like an automatic. And I think that's the point that's for me in that disciplinary process.
So, I mean, couple things. My initial reaction was it seemed a little low, but I really do feel like, one, we don't have the full panoply of information, and it definitely feels like second guessing. But having said that, I do also feel like the thing that everybody must have known was that it's the Commonwealth's attorney who decides what to charge, and apart from the numbers, to go in, as he said in advance, and basically give the correct charges. That it goes to the heart of what was wrong, and the numbers and the swapping, but that part feels to me like it's pretty baked in. But I don't think our recommendation here is going to have any effect. I mean, ACPD has addressed this, and this is an old matter, so I'm not even sure we need to vote on it. That's my own feeling.
We do have to vote on disciplinary sufficiency, and to your point, it doesn't really change anything about the outcome of the case. It's gone through the grievance period. The question is, do we feel like being given, we won't say what the number is, but, reading what the discipline was from our review of the case and saying the recommendation outside of the progressive corrective action was that this should be sacrificed as leave, not served as a suspension. Does that feel like meaningful accountability where the public has trust in the process because of the outcome?
And to me, the last part is the most critical part, is because we are the community oversight board, and it's what the community's expectation is. So I absolutely hear everything and everybody's rationale, but I believe my role as COB member is to signal what the community's expectation is of when something like this happens? And would the community expect that this would be the type of discipline they would just hear? Because sometimes I just heard it, had zero context of what's high, what's low, but this thing happened, this thing resulted. As a community member, do we think that just hearing those two things, would that meet the community's expectation of how that should be dealt with? That's how I'm looking at it.
No, I think that's also fair because I wouldn't want to give that up for COB. Like, I think
Right.
it is fair for us to say the community has a gut reaction to just what we've heard. We don't know everything. We don't know all the details, but
Yeah.
we have a gut reaction.
One thing I would say in addition to that, 'cause I 100% agree with, like, our role here is to kind of not just talk about like what is the norm, but what we think we should be pushing the norm to be. Like, we should be advancing pushing the envelope forward, pushing the ball forward, whatever you want to call it. For me, the other piece is, and as I said earlier, like, what message does it send to other officers? And I don't mean that we should go and like broadcast people's individual disciplinary history. What I mean is the culture. How are we shaping the culture? How are we otherwise sending the message that supervisors are being held to a higher level of accountability and that their actions will be treated differently than officers who are reporting to them? And that's like the bigger picture that for me was missing from this context. And that's why I felt it was insufficient. But I do think it's important that I think just getting into the weeds of like what should it have looked like is where we are not duly informed.
Yeah.
Because we don't have the full
Yeah.
picture.
And the leave hours, were they equivalent to if he was just suspended? Like, if all the hours would be the equivalent to if it was just taken in suspension? So.
Yeah. So I thought.
I don't want to belabor it too much. Quick side question. Hopefully he does a good, quick answer. For really CPD, I don't have the luxury of military names. When somebody, of course, is disciplined, you anonymize it, you post it up to shame people, but you also do it to make sure that other people know, hey, this action happened, this has resulted. And then so your point, hey, nobody knew about these policies. But then as somebody sees this kind of scroll in the corner, they're like, oh, I was about to do that tomorrow. Good that I think I didn't do it, right? Does anything like realizing you don't broadcast people's personnel information, is there anything like that so people can look, hey, somebody did a thing, this resulted, better not do
Too
that?
small.
That's the challenge. Is
Yeah.
We're small enough that it's.
That you can't anonymize it
If we
if
could really anonymize it, that, yeah, I get that.
Okay.
But we're
But
just not big enough
policy
to really
changes
anonymize.
get pushed out.
Yeah.
Through powers EMS. So
Yeah.
as
It
a
just
result
doesn't
of the
get
policy
linked
change.
to,
Correct.
this is
person.
why
Yeah.
we,
But informally, people will call certain policies after certain officers' names. 100% that happens. And I'm just being, oh, that's the so-and-so policy.
But I
Yeah.
would generally say the
Yeah.
reason why people know it's the so-and-so policy, because the person says, yep, that policy's not
Yes,
my name on it.
they're like, that was me, don't do it. That's my policy, it's
But
named
that,
after me.
they're free to
Yeah.
talk about their own.
Mhm.
personnel.
Yes.
No, I understand. Thank you.
Okay.
questions, closing thoughts? So ready to
So
vote?
much for a quick discussion, right?
Please. Okay,
So we need to articulate the thing we're voting on pretty clearly, which is, do we believe that the discipline meted out to Officer 1 was sufficient or not?
Yeah, that's it.
Or just
Sufficient or
sufficient?
not.
Yeah, just sufficient. And so a yes vote, or how would we do that?
well, we're voting to adopt the recommendation. We could vote if it was
Okay,
sufficient.
so the recommendation is.
Why don't we
insufficient.
leave it? Yeah,
Okay.
why don't we leave it that?
Just, yeah. So the recommendation is ACPD discipline with regard to Officer 1 was insufficient.
Right. But move to adopt that recommendation as our finding.
Okay.
Do I hear a motion to adopt the recommendation as the COB's finding that discipline against Officer 1 was insufficient?
So
Second.
Okay, all in favor? Aye. Opposed? Abstentions?
So what do you have? How many people voted? 3? Favor?
4.
Or-
Four, oh.
And then two abstentions.
One abstention.
One abstention.
Yeah. Or,
She abstained.
no, she voted.
She said.
Oh, nay, okay, I'm sorry.
So we do not adopt that recommendation.
Oh, okay.
Is that my fault? What
I
is,
thought
what
that it was-
counts as a?
Right, well, if there's an abstention, that's no quorum, so there's no formal, yeah,
Yeah,
okay.
it's not adopted. But that's
All right,
okay.
fine.
You should vote the way you want to
So
vote.
you buy it? Oh.
It's just this one was really bad.
Yes.
This was bad. This was very bad.
I'm gonna say we'll break after this. We have our kind of administrative updates from Mummy and myself. We've got a period for public comment. Please take a 5-minute break. It's 8:28. We'll come back at 8:33 and we'll be quick.
Yep.
We'll take that.
33.
I'll run that.
Come on.
Real quick, just quick.
Okay, apologies for the delay, folks online. Thank you for sticking with us. We had a question about our bylaws and the last vote that we took. So we're going to look into that based on, well, I mean, the vote is the vote, but we'll look into whether or not we need a majority, a physical or a quorum for the vote to be adopted. Anyways, we will clarify that in the meeting minutes and we'll bring it up at our next meeting. So next up, I believe, is the chair's update, and I don't really have major updates. I'm delighted that Joshua has joined us. I think not just because we administratively need, all hands on deck, but also he is a very kind of knowledgeable, talented, and experienced, member of the criminal justice system who brings a very specific, qualified perspective, along with, bringing a lot of benefit to the kind of diversity of thought that we need for these conversations for exactly the reason that we just had, which is, it's important that we focus on providing accountability, transparency, and accountability in these individual cases. And it's never our purpose to, Monday night quarterback to the point of ad nauseum, but, making sure that we have a conversation that helps ACPD understand what the public and what the community expects in terms of accountability. And then what we would really like to get to later this year, actually, sounds like I do have an update. What I would really like us to get to this year is beyond these specific kind of, one issue at a time reviews, taking a step back and having a meeting opportunity. We don't have a backlog of cases where every meeting this year has to be a case review. We don't have that mandate from the county board leadership anymore, that we will have the time to take a step back and say, we have bias-free policing issues that we have identified repeatedly, and we need to be able to put forward solutions for ACPD to consider and adopt. Same thing with excessive use of force, same thing probably with, disciplinary accountability in different regards. So I would like for us to be able to have those conversations. We are moving closer towards that with, I'll let me give the update about staffing, but I testified at the budget hearing for the county board to point out that, we are still dramatically under-resourced, both in terms of staffing and in terms of budget. And I recognize that this year the county board is kind of strapped for cash across the board. I disagree that they can't make more resources for us compared to the other decisions they've made, as previously, where there is substantial provision for recreational investments in Arlington. And I think our priorities should be magnified. But almost more importantly to me, and this was the point I made in the hearing, was independence of our budget effectuates the independence of our work. And so, right now we have 2 projects that are going to go out through the county from spare funding that they, pulled together from other places. And, we are grateful that that is being done, but that is not materially equipping us and supporting us to do this work in the meaningful and independent way. We don't have control over that scope. We don't, get to implement those priorities. We don't have control over the timing. And so I would encourage us that as we come kind of through this next year, we think about what our resource needs are, And so that coming into the next budget season, which will really start in the fall, giving the county board an understanding of what resources we need and what we would use it for. So as we come out of this kind of extended period of focused case reviews, where I think it was extremely useful in giving us kind of a literacy of the ups and downs and the nuance and, reinvesting ourselves in the purpose. I do want us to magnify that request next year and kind of put pressure on them with a little bit more specificity and a little bit more leverage to say, this is what we need resources for, this is what we're going to do, and this is why we need we need independence from the larger county budget.
You said we don't have a backlog.
We don't have another case that's ready to review yet.
We have a cert review for next month, but it's not going to be an investigation that you need to vote on. It will be a kind of review of the critical incident that happened in October, I think, of 2022.
Okay.
And probably some form of, CERT related training. The critical incident response team is what CERT stands for. So that's the only other one. There might be one other one that's getting close, but there isn't a backlog where we had a bunch of cases that were done and we're ready for the COB to review.
Sorry, it got so cold in here. I feel like my starting need to be ready to go. But that's all I have. Do you guys have questions, Selena?
Because they left. But I thought the report was very, very detailed in the facts and sort of as they walk through the witnesses and everything. I thought it was extremely conclusory at the findings. And I don't know if there's a way that we can make some sort of a suggestion to them, because it was like one sentence, therefore we, did not sustain. And I was frequently reading it saying, I don't understand why. They just said they didn't sustain. So I don't know what to do with that.
I think part of that is it's part of the learning process of, because I would even say that their reports have become more extensive than they were when we first started. They were used to writing to their own audience, to themselves.
Yeah.
And so they're still kind of getting used to writing to us as the audience and going into more details. The supervisory analysis being case in point, as people reading it from the outside looking in, it didn't look like there was any sort of analysis done. I know from internal dialogues that there was, but there needs to be some sort of evidence and record of that for us to be able to make an assessment of whether it was thorough and accurate. And so on. But I definitely think that it's certainly, appropriate for those sort of recommendations about the form and what is the substance of the report or the disciplinary kind of report out, as we were talking about with Deputy Chief Chamberlain, to be a part of your recommendations for an investigation.
Well, and maybe in line with that, and just to review in a kind of relevant background, that their investigation interviews have changed substantially since the COB was created. That when we look at cases that were, investigated before the COB was created, the interviews were very short, 10 or 15 minutes, very kind of perfunctory, and now they are much more in depth. That said, we have a kind of recurring issue that in some of the more sensitive cases, there are still leading questions did you think that this person was being rude or were they just being passionate, right? So,
Which are not mutually exclusive.
right, absolutely, yeah, completely. So there's definitely room for that. I will say, I mean, some of my training in this was just from being a court-appointed special advocate, where they're so picky about making any assumptions or drawing any conclusions that the back base. And I think that one message that we get from them consistently, and this is just for us to keep in mind, which is valid, that they are an employer in addition to a police force, and they have employee rights. Now they have a union, they have collective bargaining and all that stuff. And so it doesn't change what we think. I think it does give us context for how we shape our recommendations, recognizing some of the, legal constraints of their implementation, their process.
Yeah, but I think you said it beautifully, Charles, and that we have different priorities in that regard. They may be looking at it from the employer hat, and we're looking at it from the community hat, which is what we think right should look like, what we think justice should look like.
They change my concern that they just sort of answered.
Oh, no. And we say hey, give us more. And
Well,
we've done
if you
that.
don't, then,
Yeah,
you know, all we can do is use our own analysis,
That's
which we've
true.
also been criticized for, which is like, this is an opinion, and it's like, no, it is my assessment that it would be difficult for me to imagine this happening to, you know, blank. So,
To be fair, I think it also doesn't do them justice because there are a lot of underlying considerations that take place that I may personally be privy to, or that people are who are part of the investigative team might be privy to. And if it's not reflected in the report, then it doesn't show whatever work or considerations were taken into account in making a decision. To your point, Selena, you don't necessarily know how they arrived at that conclusion.
Just yet another way to pitch it for recommendation, which is if you don't explain the rationale for why you got to your conclusion, then you can't expect too many people to adopt as a recommendation because we don't understand. So.
yeah, we can put that in our, so every, and you'll see Mummy, oh, yes, Mummy just posted our first report from, we are catching up on the reporting backlog from last year's cases. So the first case we ever reviewed, we got ACPD's response and published that online. And at the bottom section, after we go through like, was it thorough? Was it, this, was it this? There is a section for like other kind of recommendations. And so in any of these cases, as we come across these things, and there's reason for us to kind of reiterate that so that for ourselves, when we do have the space to say, let's look back at the body of cases we've reviewed, here are the recommendation, here are the policy violations where we disagreed most. Here's, the recommendations that we had. Here's what they've adopted. Here's what they're amenable to. Here's where we need more research. Here's where we need more resources. That's kind of the momentum I would like to see us build this year, because this piece of it is, engaging, but it's a small piece of what, our role is designed to affect. I don't have any other updates besides really the budget. Any questions for me? Mummy?
Yeah, I will segue into my report with I report out with
Move that mouse, they can't see your screen. Sorry. No, not your phone. There we go.
I just wanted to show people where to find the publication. So this is the COB IPA website. This is where you would find the report. So it's going to be under publications. And then as you scroll down, this is where you would find the annual report or things like that of that nature. And then underneath it, the investigative reports. And so they'll be listed individually under there based on the CMP number and the published date. So when you click on that, you'll see the investigative report. You'll find the report authored by the COB, and then included with it is a response from the police department. So they'll be published simultaneously together, and it'll all be in one document there.
And that one is only signed by me because Gary was our co-investigation lead and he wasn't here to agree to sign off on the report. The investigative reports, we will have both co-leads kind of sign off on the report so that the public has some kind of sense of who led the kind of thinking on those things. But I didn't want to put Gary's name on something that he didn't have a chance to see. We miss you, Gary.
So yeah, more of those to come on there. I will probably send out some alerts, to let people know that they've been published in case people, want to read them. Because I don't expect people to just be looking at the website every day. So whenever we have updates to the website, I'll send an alert with it and let people know kind of where to find the information. My other main thing that I wanted to say was that we put the senior management analyst position posting back out. And it's been out for a week now. It's going to close this Thursday at midnight. So it'll be
Tomorrow.
linked to, yes, tomorrow at midnight. Tomorrow's Thursday already. I posted the link in the chat just in case anyone is interested in either applying or sharing with their networks. Again, you have until tomorrow at midnight to submit your application. And again, this is for the position that would provide professional support both to the IPA as well as the COB. And we're looking for someone that has data as well as policy analysis skill set. Other than that, because this position is still vacant, I think it's safe to say that, both annual reports for the IPA and the COB will not come out at, the normal scheduled time, because I think what's important in these sort of reports is a kind of real crunching the numbers for the complaints and seeing kind of where we spend our time and what our priorities are, what are some of the trends that are coming out of it. And then, figuring out how we want to respond to those or set our priorities. But we should certainly have like the numbers and everything to kind of accompany those recommendations. And that's what our data analysts would provide. So I'm hoping to get that position filled really soon. And then we will definitely resume our publication of both newsletters as well as the annual reporting or our quarterly reports that we send out to you guys as well. I think that is it for me. Oh, the one other thing I just wanted to say too is I think Julie did a really phenomenal job at the budget hearing. And I think the theme of just kind of talking about like what the resources are that are needed to do, to continue to mature the work that we're doing here is really important. I think at some point we should go back to the basics, like look at the ordinance and like list the things that we set out to do and the things that we have done and the things that we would like to do or the things that we haven't been able to accomplish and why, so that there's a clear picture of what we are currently doing with the abilities that we do have and what we would like to be doing or what we could be doing if given additional resources.
I will circulate that briefing. I think we did that last year, but we are still finding very short-staffedly. So I'll circulate that so you guys can see what we presented. And it did have a list of like everything we're supposed to do. And it was green, what we are able to do, orange, what we're like really kind of trying to do. And then there's a long list of red items that we can't get to because we don't have the staff resources and we don't have the budgetary resources. So we're doing a corner piece of what we're doing and we're getting, a lot of feedback from different perspectives, but we can't do the broader work without, more resources. So thank you.
Well, getting you clear. I thought the PowerPoint slides really.
That was, yeah, I like that. I like that as well. It's a nice addition.
I meant for them to be circulated sooner, but again, we're trying to keep things moving. But I do think, there has been a, feedback mechanism that, I got from, COB members and from ACPD that, if we don't have a visual aid, we sometimes can like wander around to different parts of the issue. And I think it was helpful to just kind of have a focal point, but I think in practicing that, we can make sure that, Mummy and Albert both kind of have that flow and are able to still represent their kind of inputs faithfully. But yeah, I think being able to see what we're talking about is helpful, especially the policies. Right. Well, and just trying to follow along with like, who are they talking about? So thank you. Anything else from the board? Open discussion?
Great job bringing the community together, everyone. I thought that was a great event. It was well attended by the community. There were snackies there. There's a lot of great questions there, which was even better. And everyone seemed very engaged. That was a great public forum. And again, as the bandwidth will allow, we hope to get back out there in real life, RIL.
Yeah.
To you out there in TV.
We have some follow-up meetings with folks from that and an outreach. I still have to connect the dots with Jim, but yes, just a note to the public, since there are still some folks listening, we do have a vacancy still for our non-voting second member position. So yeah, we will have a period for public comment if there's anyone online. I don't think we received any requests for public comment, but if anyone wants to speak for 2 minutes at a time, please raise your hand. Otherwise, we will thank you again for your time this evening. And that completes our agenda.
Okay.
Meeting adjourned. Thanks, everyone.
Meeting.
See you next time.
Yeah.